Right.
Yeah, great. Well, listen, thank you, everybody. We appreciate you making the effort to either come next door, if you're right next door, or come several blocks away when the wind and the ice blew you in to the Bar Association. We were thrilled to have a chance to sit down with the Judge John Russo from the Court of Common Pleas. I have to say, I'm always stunned when we have people who are of such import in terms of driving our profession and driving the justice system that we don't pack the house. So I can only assume that it's because of weather. So probably what we'll see is we are joined by friends on Facebook Live. So thank you those that have come on. I want to encourage you right out of the gate, if you're joining us online or if you're here in person, if you've got questions, we would really welcome your questions. Our conversation today is really an opportunity to pick up where we left off with our October Hot Talk, which happened on October 8th, where we had Judge Michelle Early from the Cleveland Municipal Court, who was here talking about bail and bond efforts that have been underway in that court and pretrial services that have been changing and evolving in the recent 2+ years. And it was a great conversation. I got to say right out of the gate, when I walked out of that dialogue, which was so productive and interesting, I immediately reached out and said to Judge Russo and to County Executive Armin Budish, who had just announced what his new budget was, budget proposal is, which includes over $1 million for bail and bond related reforms. Invited them both. Judge Russo responded in about a nanosecond, and notwithstanding multiple requests to Executive Budish, we still have not heard back from him. So I'm a little disappointed that we did not have opportunity to have him or someone from his office say yes to the opportunity to have a conversation, but I really am thrilled, as always, that you are here. Judge Russo, if you don't know it, is a member of our board of directors here at the Bar Association and has been a very active member through presentations and mentoring and communicating with the next generation of lawyers, which I know is a passion of his. But one of the cool things I will say about him is as good a friend of the bar as he is, and as good a friend of mine as he has become in the last 5 years, we disagree on a variety of issues, and what I welcome is the opportunity to always have a thorough and thoughtful conversation with him, where even when we disagree on topics, I know that he is going to be as respectful of me as I am of him. So again, I want to say thank you for coming.
Yeah, thank you for having me. We don't want to not point out that someone rode a scooter over today too. So that's pretty amazing. I'm not going to say that. So thank you for coming.
It is. I think the legal industry thanks you, because there are more and more claims now that are coming up of people who are riding their scooters. But thank you for being here. All right. So our conversation, Judge, I was hoping that we could start sort of with a little bit of context. And for me, I know that discussions about bail and bond reform and pretrial services and how to build a stronger system is not new. You've been the presiding administrative judge for 6 years.
Yes.
I've known you 5 years in my role here at the CMBA. And I think from some of our earliest conversations, we were talking about new and different things that you were thinking about in terms of change driving in the system. I would love to sort of start maybe with the bail and bond reform task force that you assembled back in 2018, actually it was 2016, that came out with a report about 2 years later. Could you start by just talking a little bit about that group?
Sure. I think I would say to maybe kick off at least a thought process, a little melancholy coming with 6 years as being the administrative judge, and I was telling Becky that I was listening to a podcast coming back from Michigan this weekend with Elon Musk and some of the things that he envisions and things that he has done in his life. And the one quote that he said is, what drives him to where he thinks out of the box or thinks of the things that might be advantageous to the community or to others. And his comment was his goal when he starts a project is to make whatever the project is or whatever the end result, he would hope that he leaves that in a better place than it began when he started to look, with the modeling of a car and electric cars and all these other matters. And so it made me, pause as I was driving in saying, well, I hope the last 6 years that I've taken the court, the judicial system to a place that it's in a better place than it was maybe 6 years ago, with the anticipation that, that it continues to move in that fashion. And so 6 years ago with bail and bond and this idea that, as you say, wasn't a new idea, this idea of centralized booking. And I really think that we're going to have a conversation about that. I think the executive and his team have decided to maybe sit down now as a group and have that discussion. And so that's coming up in the next couple of weeks. But really that idea of how do you collaborate with all the judicial branches in Cuyahoga County in order to make a system, a better system than where we are, a more efficient system, one that's constitutionally protective of those who are brought before us as accused, and then to make the system fair. And so looking at that 6 years ago and looking at bail and bond and looking at how the accused are charged and then where do they go once they're charged. You know, not just Cuyahoga County, but the state of Ohio with our Chief Justice, having a chance to be a court administrator as the administrating judge and presiding judge, getting involved nationally. It's not just here in Cuyahoga County, so it's this national idea of looking at bail, bond, and bond setting and how we do things. And there's really been this when it started and constitutionally, and you know, it was all cash, and then it was all, you know, percentage, and then it was nothing. So it has been a roller coaster, and it's really, where's this line that we're going to try to make, which is fair to the community, it's protecting those in the community, but it's also fair to those who may not have the availability of money to find themselves out of the accused situation with bail and bond. So tasking that in 2016 and having that report given to us, I have said to the CJC, which is the Criminal Justice Council, that in December I'm going to have a response to those recommendations that were provided to us. So I think as a court and as me leaving as the administrative judge, there are a number of recommendations made, and so I'm going to give a written response to that. I'm currently in the process of drafting that, and then leave that with the next administration on these are things we've done or attempted to move, and then these are things that we need to continue to look at. So I am going to do that overall, but I think the task report that came out really looked at the criminal justice system as a whole. And a little bit of a challenge there for me as the administrative judge. You know, I don't have control over the municipal courts, but yet I wanted to build a relationship with the municipal court judges that allowed them an opportunity to have a voice. And all I would say is in the past, maybe that wasn't always done. Sometimes when you thought about reform in Cuyahoga County, it was just pushed out there and said, okay, follow this, without input from everybody. So I thought it was important to bring the judges, to bring their staff, to bring what I would hope to be the next step, the mayors and the council people of all the municipalities, so we can talk about what is best for Cuyahoga County and moving forward. So that was the vision I had, and I think that's where I've continued to try to strive over the course of time.
Well, I don't want to take away sort of the excitement of the reports that you're going to be releasing before you leave the AJ role at the end of this year, but I know that there have been real changes that have been coming. One of the areas that we talked about a month ago with Judge Early was about some of these, the presumption of release instead of financial bond being the presumption, and the risk assessment tools that have been before use now in the Muni Court for about 18 months or so. There was an article a couple weeks ago at Cleveland.com talking about a pilot that you're starting that is focused on this sort of risk assessment and what's happening with no bail release. Can you give us a preview of sort of what this pilot is and what's happening?
Yes. So when the court started to look at how we set bail and bond in Cuyahoga County, you should know that anywhere from 55 to 60% of all felony cases come from the Cleveland Municipal Court. So we knew they were using the Arnold Foundation tool, and they were using that tool on the misdemeanors and then binding the felonies over to us. You know, as you say, some things have been put in place which have been good and have moved our process to be more transparent and at a pace that's a little expedited, and that's what the first appearance docket. So we started the first appearance docket a few years back, and that gives us, after 4 days of a felony coming over to the Common Pleas Court, we would do a risk assessment and assessment for bail and bond, and they would have an opportunity to see a judge within 4 days. So that's been implemented. It's currently being done in all suburban courts and in the Cleveland Municipal Court. And the question was, how can we close the gap to 0 days, right? So when someone comes into the criminal justice system on a felony, how do we begin to assess that instead of these 4 days? Now, I'll say, some people say, oh my gosh, 4 days, you're waiting to do it. And you should know that before that, it was averaging around 30 days. And so we moved that time frame down to the 4 days, and has been pretty effective on every felony coming out of the suburban courts or the Cleveland Municipal Courts. But still, room for improvement.
Yeah.
And how do you improve that? Even the 4 days, you know, the statistics show 4 days locked up, you know, you lose your job, you then lose your place you're living in, and you lose
Your
kids,
you lose your place to live,
lots of
all
everything
those
going
things,
on.
right.
So how do we close that gap? And so that's where we started.
Okay.
So what did we do? We went to national models outside of Ohio. We looked at Denver and Colorado. We looked at Massachusetts. We looked at different states on how they assess no bond and bond. So someone who would be presumed not to have to post a bond and released immediately with pretrial services. And we began to look at a matrix. So we have developed a matrix. That matrix, matrix would show that certain parts of the matrix is a no bond, and then certain high risk parts of the matrix would cause what we would call a bond hearing. So everybody on this side would be released. If you take the matrix, there's one section of the matrix that says you come in and your risk level is low, and your what we call criminogenic needs. So we're also looking at needs of the person, not only the risk of whether they're going to come back and report for a pretrial or an appointment in front of the court. What we're looking at too is what we call criminogenic needs. What do they need? Do they need housing? Do they need a case plan with their mental health provider so they stay on their meds? Do they need currently inpatient treatment now? Do they need a GED to help them with their job? Can we get them to the union and start? So those needs are things we're looking at too. The needs come from, you know, the economic needs, but your social needs and your family needs. And so we're looking at both at the same time. So the matrix says, if you're in this quadrant, you leave. No bond, you're out. The next quadrant is, well, we want you to report to probation, which would be a pretrial services, but you only need to report once a week. And then that risk level continues to ramp up to even where the point, as you mentioned, the executive has provided a dollar amount in his budget. So hope at the beginning of December, council approves that budget. But that would give us GPS monitoring, or that would give us a monitor that we test alcohol with, that we would put a tag on your ankle. It would give us the opportunity, maybe now, to give you intensive outpatient treatment. Beds available for inpatient treatment. All of that being provided to you before you've even been indicted or charged by a grand jury. But again, that opportunity for diversion would exist on day one. And again, so diversion would be, should you even be charged as a felon? Should it be a misdemeanor? Could you be part of the diversion that the state allows, where your case could be charged, you complete program successfully, and your case is expunged and you don't have a felony on record? Can you go to drug court, veterans court? Can you go to mental health docket? So we're doing that at the very beginning. So the matrix is designed to use the Cleveland Municipal Court's Arnold Foundation tool.
Okay.
We wanted to make sure that the municipal courts still had their authority in setting bond. So if they're using their Arnold Foundation, our matrix is off their Arnold Foundation. So if you scored a 1 to 6 on the matrix for Arnold Foundation, you find yourself in our matrix based on their Arnold Foundation. And we're asking the Cleveland Municipal Court, and we received their approval through Judge Early, that they would use our matrix to label with their Arnold Foundation, and we will have staff now in the very initial hearing. So if you're familiar with our docket, it's called 3D, and that's, I'm sure Judge Early spoke about 3D. So our staff would be in 3D. We would interview that person immediately. If they're given a release with no bond, our staff is going to be there, so they're going to meet our pretrial services. So municipal court would use the matrix, set a bond or not set a bond, and send it down the road to our judges.
So if it's a matter that's coming to 3D from the municipal court, is there any need for additional assessment, or are you saying that if the assessment is completed in the municipal court, then the Court of Common Pleas in 3D will use exactly what's been assessed?
Exactly. So what would go away is the first appearance docket. So the first appearance docket, 4 days, would go away because everything would happen at the initial stage. Because we're not doing it with the suburban courts right now, we can't do away with the first appearance docket. And we're testing it. So yes, yeah, the answer to your question is yes, our staff is there. Now what could change, let's assume it's a personal bond and you're released and you're reporting once a week. What could change from that day in 3D to when you are arraigned in the felony court? So things could change. So it goes down to the grand jury and they indict you on something of a much higher risk or a higher charge, or something that happens to change. Or over the course of the time where you're indicted, you didn't show up for pretrial services, or you didn't go see the case plan, or you didn't report to the probation department, or you failed to appeal. So you set a standard that maybe when it comes to the arraignment, the bond might be changed, or there might be a cash bond, or maybe we would ramp up and put an ankle bracelet on you. So there are things that could change by the time it comes to the arraignment room. But yes, our services would be provided in the very beginning, right out of the 3D in the municipal court, and it would continue to hold true all the way through the arraignment room. Look, I had to get buy-in from 33 judges.
So that was going to be my question.
Yeah,
It would be good if you could talk a little bit about that process, because one of the things that came up in last month's Hot Talk was the discussion about, I think it was Judge Adrian who really kicked things off with the Arnold Foundation and their assessment. And moved pretty quickly in moving things forward and getting it adopted by the judges on the municipal court. Judge Early continued it, and they've been off to the races and running, and they've got really good data now for the last 12 to 18 months. And so one of the flip side questions has been, what the heck is taking so long inside the Court of Common Pleas to adopt same or similar kinds of changes?
Yeah, so as the administrative judge, I'm elected by my judges to oversee the bench. I like to, for those of you who would say, what does the administrative presiding judge? I'm the CEO of what I consider a Fortune 500 company. So even though we're a government agency, I like to look at us as a Fortune 500 company. And I have 522 employees, a new one that I met this morning, because I meet every new employee and have a personal conversation with them. So we're excited to have her in our drug lab. But that idea that I'm the CEO, who are my investors? So as a CEO, just like you report to a board of directors. Well, my board of directors are who? My 33 judges. And so that's who I report to. So unless I have consensus with my judges and I explain to them the process and I do it in a way that there's buy-in, that's what I do as the administrative judge. So the very first thing, and I'm going to give a shout out to someone who went through one of your leadership classes, and I think my leadership nominees have 1 year project 2 years in a row.
Well,
at least set on
setting a high bar.
High bar for
Yeah.
for my two that are there now. But Andrea Canast, our one of my deputy chiefs, she worked very hard herself and her team with developing the matrix,
Yeah.
and so the probation department. So go back to your question. I have 33 judges, approval that I have to get. Then I had to go to Judge Early and make sure that it made sense to Judge Early and her judges. And then she has to get that approval from her judges. So she is elected the same way I am. She runs a Fortune 500, or maybe less, well, I think about a Fortune 500. But, so you're looking at both of those. Then you're looking at where do funds come from? How do you have to reorganize your organization? Because you need to move people, hire people, and that process of taking an organization and now saying, hey, guess what? We're not going to work out of the 12th floor. We're not going to go see you in the county jail 4 days later when you're in the county jail. But we're moving all our staff and we're moving our services up front. And what about these new GPSs that we need and these new TAD monitors? And how are they going to be monitored? So we've had to reorganize. So we're currently, not only did I have to get the buy-in from my judges and from the municipal court judges, I had to get buy-in from our county executive and where that money would be and how that money would be spent. I had to reorganize, or at least propose the reorganization of the Common Pleas Court, which we've done as well. And then I had to be able to say, these services that we're going to provide, how are we going to provide them out of 3D? And I had to make sure that our services, for example, beds, recovery centers, mental health planning sessions, how's that all going to work? So it took some time, and it took buy-in, as you know, and I think we're at the point now where I have the buy-in. So where are we? What I've asked to do is to verify our matrix. So in other states, while they develop the matrix, using the tools and the needs assessment and the risk assessments, does it truly play out that 75% of those who appear on the matrix are going to go out on a no bond, and 25% are going to move forward with a bond hearing? So that's the ratio percentage about around the United States. What does the model look like here in Cuyahoga County? Well, we don't know that. So what we're doing right now is, with the approval of Judge Early, we have taken their cases from, we're going back 3 months and then currently recording data as it's coming through on a daily basis. And we're now plugging it into our matrix to say, so where does the balance come? Do we have the tool off based on 50-50? We're putting more people in the jail than they are right now. And so we're looking at the matrix before what we hope to roll out in January.
In January. And so as you wrap up your time as administrative judge and Judge Sheehan prepares to move into the role in January, do you envision there being any further delay or disruption because of the change in leadership at the top of the courthouse?
Yeah, so I see Judge Sheehan being our newly elected administrative judge, not presiding yet until our December meeting.
It's not yet.
Yes, but you know, Judge Sheehan has spoke publicly about wanting to continue the trend of modernizing and moving the court in a positive way, and looking at how we handle, whether we call it centralized booking, or we call it the 3D docket, or we call it the matrix, whatever it is. But Judge Sheehan is also, I'm encouraged that he wants to continue. What's going to be key to us is where do the numbers fall? So when I say the beginning of January, I would love to say that the matrix we created is such that it falls in the model of other states. But if it falls maybe out of, statistically out of what it looks to be more people in jail than what we had anticipated it to be, then we probably have, not probably, but we have to go in and modify the matrix. Then we would have to take more data, maybe even go back and redo the data that we have to see how those numbers would fall.
Okay.
So statistically, if the matrix works, and it's statistically set up that the percentage is what it is in other states, I think we move forward come January.
And that analysis, the verification, is being done by members of your staff?
Yes, right now.
Okay.
With the, again, Judge Early and her staff have been great with us, because they have to turn over all the, we decided to go back to September, October, and then continue as the, so we would get 3 months, if not 4 months of data that we can look at.
Okay. I'm going to take a pause and see if there are any questions at this stage of the game, or if we've gotten anything from Facebook. Yeah, please.
The numbers that you're just talking about whether or not the percentage is being released on the personal through your matrix, are those numbers going to be available for the public to review, and not just what's being said?
Well, I don't see it being something that we're not going to share, but to understand the matrix and where individuals fall, you know, I think that process will be discussed as well. But yeah, I don't think nothing's going to be hidden. Yeah, so they know that we're doing the matrix. They, meaning the general public, and I think my stakeholders know we're doing it as well.
Now, the people that are interviewing the defendants to determine where they fall at in your matrix, what kind of training are they getting? Are they just,
So they're currently our bond commissioners. So they're currently my team now. We would probably add 2 or 3 new individuals who are trained already. So it's the same office, but we believe that whole office would transition to what we would call pretrial services, as opposed to a bond commissioner office. So.
Thanks, good question. Other questions?
So I guess one thing maybe I didn't explain,
Yeah.
Becky, is so that low half of the quadrant that says, hey, there should be a bond set. So we're going to use that opportunity to say, go to a judge and have a hearing. So the judge in the arraignment room, again, I had to get approval from my judges, while they won't be doing the first appearance docket, we'll be doing a bond hearing docket. And Again, lawyers, public defender being part of that process initially, even though they don't have all of the cases, we would have a public defender who would be independent and dealing with the issues of bond and knowing what arguments to make, interviewing the individual who's been detained, finding out, job, employment, those type of things and connections, and then the prosecutor as well, and then having a full hearing on the record with the judge in the arraignment room, arguing what the bond should be set. There will be a bond recommendation given at that point in time from a bond commissioner, and then the parties would have an argument in front of the judge as well.
Got it. So as you work your way through this pilot phase, I think I heard you say between now and the end of December.
Yes.
And assuming all goes well, then you go full bore come January. The report that you're going to generate by the end of December, will this be discussed in that report in terms of current information and how this matrix is working?
Yes, so it would be one of the recommendations of the bail bond
Yeah.
task force was to use a matrix and use a tool. I'll speak in my response to the tools that we have been using since they published the report, and then where I think the court might be moving as well.
So one of the other recommendations that came out of the task force was around this concept of centralized booking. You mentioned earlier in your remarks that as part of the executive steering committee that's focused on the Justice Center and what comes next with our Justice Center, there's a working group, I guess, that's been assembled or is about to be assembled next week for a deep dive conversation around the topic of central booking. Do you want to talk a little bit about that effort and that conversation that's coming up next week?
Sure, I would say this. So before the Criminal Justice Council was put together, there was something called JSR, so the Justice System Reform. And that was something that in the former three-commissioner government was run by Tim Hagan, Commissioner Hagan at the time. And I guess the reason I go that far back is I've been on the bench. I'm just going to finish and start my 16th year. The discussion of centralized booking has been discussed since I became a judge, and I remember going to the first Justice System Reform conversation. And this is what I would say, Becky, and to anyone here is centralized booking, as you've read maybe from Pete Krause and some of his articles written about in Indianapolis and how does that come into fruition. The reality is this: you look at Franklin County, it's one county, right? They have one sheriff, one police force, they have one municipal court, they have one common pleas court, they have one clerk of court, right? So how does that concept move from Franklin County to possibly Cuyahoga County, and what would it look like? Similar to those discussions had in Indianapolis, which caused all sense of will there be issue of diversity that we'll lose with diversity? Will we lose the east side and the west side and representation? How would that look, and what would it look like? I believe that the discussion is much bigger than this collaboration group that's going to get together next week and start to have an initial discussion. I believe that we're missing people at the table with that initial discussion, looking to see who was invited. And I'm hoping as we draw out of that meeting next week that those that are missing from the table will be invited to a discussion. Because it's not something that Cuyahoga County can say, this is what we're going to do, and you suburbs, you're going to follow it. There has to be buy-in from the suburban mayors and the suburban councils and the suburban courts and their judges, their probation staff. Everybody needs to be on the same page about what would it look like and how does it look looking to the future. And so I'll say this delicately. To read about it in the newspaper that the county executives wants to discuss centralized booking as the next thing they want to do is concerning to me as the administrative presiding judge, and I've said that to response to that, because it's not just something that can be put in place and people told that this is how it's going to be done. It has to be collaborative. It has to be a sit-down discussion because money's involved, right? There's money that the municipal courts have that come into their budgets out of the municipal court arrest. And that's done by statute, so I'm not saying they're doing anything wrong, but if those discussions aren't had, I think that little discussion doesn't become what we really need is the big discussion. So
Well, I'm looking at who's been invited, and it looks like, so Judge KJ Montgomery will be there on behalf of the suburban courts representing the Northern Ohio Municipal Judges Association.
at my request,
At your request? Okay.
I went, initially I said, if you don't have somebody there, and while she doesn't speak for the municipal
Sure.
courts, she does relay the information
Yeah.
back to them as their representative.
Yeah. Are
So-
there others that, because it looks like, so there, according to the notice that I got, and this workshop is happening November 19th from 8:30 to 12:30 on the 12th floor of the Justice Center. It looks like, at least invitations based on what I saw last week, have been extended to Common Pleas Court, Municipal Court, I mentioned the Suburban Court, then the prosecutor, the defender, the City of Cleveland, Sheriff's Office, the county as a whole, Metro Health, and then I see TBD on the criminal defense bar. And we at the CMBA also have 3 individuals that are going to go and be a part of that dialogue. Are there others that you think should have been included?
Yes, yeah, so I think the clerk of courts, again, not just ours, but all the clerk of courts, they handle those bindovers, they handle, anything that comes from the clerk of courts goes to one place. So now we're talking about centralizing, but they're not at the table. And I see our clerk in the back, but
It was very funny because as I was saying to my chief of staff, when is this meeting? What's going on? So can I show up? Judge?
well, you could ask the chief of staff, Bill Mason.
Mr. Mason, if I
He-
can show up?
They put the meeting together through Jeff Applebaum.
I will check with him.
Yes.
Thank you.
And
Sure.
I'd be glad to share the copy that I got actually from Judge Russo letting us know when we didn't know about it either. So I'd be glad to share if you'd like a copy of it.
Thank you.
Yeah, I think we have a question from
We do,
Facebook.
we do. This is a multi-part question from Facebook user Mar Will. It says, could the judge expand on the criminogenic needs of inmates and how it determines the next step for the individual? How do you determine who is eligible for the diversion program, and will the public have access to this matrix workflow?
So let's start with the criminogenic. I gotta say, that's a word that's new to me in the last 30 days.
Yeah, so criminogenic needs, so we're looking at the person, right? So we're looking at the person, so like I said, maybe I didn't explain it, I apologize. What are they doing for employment? What's their education? Do they have addictions? And what are those addictions? Do they have mental health issues? What are those mental health issues? Do they have family structure concerns or needs that they need? And then you loop all those together and you look at weighing those. When we just look at someone to put them on probation, we look at criminogenic needs. What are their needs? What are their substance abuse needs, their mental health needs, their family needs? Those needs, and then how do we address them in a pretrial service program with outside agencies, with doctors? That's one of the function that we look at in addition to are they going to come back and what's their risk of reoffending in the community, what's the level of crime that they've committed, and the other factors out of the bail bond. So the criminogenic needs. The matrix, again, right now the matrix is being created and being tested. I don't believe that's a matrix that's going to be a secret matrix. I think until we believe we tested it and it falls in what we believe to be a random sample that is being used in other states, I then believe we share that, and I don't think any of that's going to be hidden from.
Okay.
There was a
I
third
think the
question.
second part was who qualifies?
Oh.
How do you determine who is eligible?
Yeah.
Yeah, so for that's a great question. Some of it is by statute. So the statute, for example, intervention in lieu of conviction is a statute and says under the statute you qualify if you meet these offender goals. The prosecutor has a diversion program. So if the prosecutor fits you into their diversion program, then you have an opportunity. And the other ones are court-run functions with Veterans Treatment Court, mental health docket, drug court, and then is it a first offense that possibly you could have your drug case complete successfully the program, dismissed and expunged. All of that comes into play. All of them are evaluated by coordinators. And again, the court runs some of those, the prosecutor runs some of those, and the law explicitly allows for some of those as well.
Questions here in the room?
I don't know if I finished. So not only the clerk of courts, but we're missing the mayors. So you're either going to invite all the mayors or a representative that represents the Mayors Association. The prosecutors. So there's a suburban prosecutors. It's not just our prosecutor, Mike O'Malley, but it's the prosecutors in all the other courts that bind cases over, and there is a representative. The police. So who's the representative of the suburban police, as well as the county? So there are other individuals that, just quickly off the top of my head, that play a part in an arrest that happens in Shaker, that gets that person brought right downtown on a centralized booking. And so all of those parties, I believe, need to be, I may be missing some, but I think those groups have never been part of the centralized booking conversation.
Well, maybe through Facebook we can get them to be aware of it and to come, because I can't imagine anybody would be turned away if they showed up at next week's conversation. Karen, did you have a question?
Judge, thank you. And in terms of bond reform, I was wondering if you were aware of some legal scholarship that has looked at bond reform efforts in other jurisdictions and found that in the law of unintended consequences, they sometimes have exacerbated or baked in racial bias. And I'm wondering how we will keep racial bias, whether you're aware of that, and how we will try to avoid those unintended consequences.
Yeah, so I am aware of it. I'm aware of the reports you're speaking of. I'll say this from a larger perspective, is I sat on the bail bond task force appointed by the Chief Justice just recently. Our report has come out as well. I think the challenge is really a challenge that our Chief Justice, I think, has continued to push, is when do we start collecting data as a state, right? When do we start looking at statistics, going as far back as when I sat on the death penalty task force and Kent State was willing to do statistics on racial bias and the imposition of the death penalty and how it was being charged. But for reasons that became very apparent in those discussions, there are some who don't want that to happen, right? Or have pushed that aside. And I would challenge those who are in authority, up to all of my justices on the Supreme Court, that there should be statistics gathered here in the state, and not just specifically Cuyahoga County, to start to look at the racial tendencies and whether there is bias built in, and whether it's something that may be not assumed to be happening, but in fact is happening. And there's a lot of other concerns as well when you look at the charging and where the charging's happening and where the felonies are coming out of. And not to say that any prosecutor is doing anything intentionally, but where are those coming from? And I don't think we've actually looked at that data, but I think it's important to do so.
So Judge, do you help me understand, do you feel that Cuyahoga County has to wait for the state to give the go-ahead to collect that kind of data, as opposed to together deciding for our community that it's critically important to collect that data?
I don't think it has to be a state mandate, but I think coming from the top down makes it easier, right, for whoever is the next administrative judge or administrative judges throughout the state. So if it's a top-down approach that says, hey, why don't we all start looking, and I think the chief's been discussing, the governor was talking just recently about gathering data on those civil stalking protection orders and how do they get inputted in a system. I know their technology with blockchain, there's availability to, even though we aren't using the same computer program, right? That has been a concern, is, well, we need one case plan to be used throughout the state of Ohio. In fact, today's technology, you can have two different types of case management, but if you input it into a blockchain that can digest all of those, you may be able to have that information available regardless of what type of computer program you're using. But the question is, when the ACLU asked us for some of that data with the report that you have in your hand, it was hard to get, right? Because Shaker was doing it different than Strongsville, than different than Parma, and no computer system was talking to each other. Some of that data wasn't able to be gathered into a program, and I'm not saying that any of that was done purposely, right? I'm not saying that at all, but it is the truth, is that everybody is using a different program. And I think even at the time the report was being run, and there was this concept of, well, maybe we should start moving to one program. You know, Beechwood had just invested a large sum of money in a new computer system for their police and their arrest. And so it's a problem, and it's out there because each of the jurisdictions independently have their own programs. But I believe that technology is such that blockchain will allow you to put it into a program. I've spoken to someone formerly at the National Center for State Courts, who's now out on his own about some of that. And I think it could be done, but I think top-down would be better because then you move the whole state to a place.
So the report that you're referencing, again, this is the report of the Cuyahoga County Bail Task Force that came out in March of 2018. And one of their specific recommendations was that there be a uniform database. So as you get ready to write your December report, that is a response to the March 2018 report, has there been progress from your view made on this question of creating, if not a uniform database, at least an ability to collect and to share data amongst organizations and agencies?
So the answer is no.
Okay.
Nothing's been done, but
Yeah.
as the administrative judge, I think it was important for me to build a good relationship with all of my judges who run their courts in the suburban courts. And so I think I'm leaving with that intact, having good dialogue and open lines of communication. Similar, you know, when we don't agree on something, we disagree, but it's always been in a way that's been respectful of each other's positions. And I believe Judge Sheehan's I already saw that he's invited those judges for a meeting in early January to continue that dialogue so that that relationship continues. I think that's very important. And so to answer that question, I think while we are that third branch of government, to get to a point where that might be a reality has to come from an executive level. And so I've had discussions with the executive that, again, this idea that a meeting needs to be had and what is, you know, we talk about regionalization as the county executive, and we talked about that position. I know that Ed Kraus was working towards that before he left to be mayor. And so I don't know if his position's been replaced, but that regionalization of a computerized program and how that works, and could it be all put into a blockchain program, I don't believe it's been started. I don't believe there's been a discussion. I think it needs to come from someone that has the authority to command those individuals to come to a meeting.
Got it.
I don't think I command that to mayors and
Yeah, fair enough.
to come and hang out with me.
Fair enough. I actually, through the wonders of technology, got somebody texted me a question. And the question is, could you explain the difference between the Criminal Justice Council and the Executive Steering Committee that's focused on the Justice Center?
Right, so as I said, in the old form of government, there was a group of stakeholders that met, and that was called the Justice System Reform Group. And it was formed, you know, years ago, that there would be a meeting where all stakeholders were present in a room at the same time. At some point in time, right before I became administrative judge, those lines of communication were deteriorating because of the new form of government, with the executive coming in and not having commissioners. I believe that the executive believed that they could take the power of that justice system reform and direct and tell the branches of government to do things a certain way. While that was coming to a head, I stepped in as the administrative judge, and at that time removed the court from that group of stakeholders, again called the Justice System Reform, because I did not believe that where it was moving with the executive directing and telling the court how we should be a third branch of government, how we should function, was in fact something that was going to be fruitful and or going to be something that could be collaborative in the future. And so I made that announcement. I did that publicly to the community. While we walked away from that, I still believe that the stakeholders at the table are important. And I, on the back end of this, formed the Criminal Justice Council, and it again collaborates with all stakeholders, but in a different form, a memorandum of understanding, where we now meet quarterly And that is slowly beginning to gain some teeth and some working document and force, not as much as I had hoped it would be. For example, I would have hoped the conversation of the centralized booking would have been brought up at our Criminal Justice Council meeting in October, and it wasn't, and then 2 weeks later it was in the Plain Dealer. And so that's the forum to discuss it because everybody is sitting at the table at that time. The steering committee is the council, Cuyahoga Council and the executive hired an outside programmer to come in and look at the courthouse and the jail and to decide, can we rebuild and renovate the current jail and justice center, or do we look at building one of the two outside of the where it is currently now? So the county hired an agency called DLR, and they're called programmers, and they're looking currently now at the data as well as the structure of the two buildings and looking at, are there opportunities to renovate that building and the jail, or move somewhere else, or do some half of what, maybe renovate one and move one. So they're looking at that right now, and part of that process has a steering committee was formed in order to vote on how we move forward here in Cuyahoga County. So the steering committee was put together with the memorandum of understanding. That took about a year for me to get that in signature form with the executive, with some negotiations with the 12 steering members, 13 steering members. We signed a memorandum. Just 12. Yes, we tried for 13. And so those those stakeholders are called the steering committee. We meet and vote on different determinations as we move forward. So the steering committee is specifically dealing with just the Justice Center and the jail, while Criminal Justice Council deals with anything in the criminal justice arena, juvenile court, municipal courts, common pleas court throughout the county. I hope that answered it.
That did, that's a good question. Yeah.
Does that steering committee, I've searched all over the internet trying to find out when they meet. I assume it's open to the public, this is all public stuff. How do you find out how to attend those?
So I'm going to interrupt the judge for
Yes.
just a second and say that here at the Bar Association, we had the same discovery and the same challenge, and so we've made it easy. We created a landing page on our website. If you go to clemetrobar.org and do / or is it /, Brennan? / there we go, / justice. We are posting and will continue to post everything about the steering committee on one page.
When you know about it.
When we know about it. When we know about
Or
it.
when
So
I
the
forward
minute-
it to you.
The minute we learned about the working group on centralized booking, we put it on the website. So there is within the county website, there is, I can't remember where it is now.
I've looked there.
Yeah, it's under there. I can't pull the title. It didn't make sense to me. I had to search pretty hard to find it. So we decided to eliminate the challenge. And to the extent we know of anything, and if any of you learn of anything that you want to share with us, we will get it up on the website. So whether it's news coverage, whether it's public meetings, whether it's, I don't even know if this meeting next week on centralized booking is considered a public meeting or not, but if we know about it, we're posting it. And I, for one, would encourage you on a personal level, go to those meetings. If you're interested, go. Go. Other questions in the room?
I have a question.
Yeah, Mary.
I know you do a lot of mentoring and education to a lot of the kids in the Cleveland schools and other school districts. I encounter a lot of kids, as you do, that are pretty cynical about public service and government jobs. What do you say to them about, you were drawn and motivated to run for office, and I assume that you have enjoyed it as a career. What advice would you have for those cynical youngsters who maybe aren't looking far enough into the advantages of public employment?
Yeah, so I would say, first of all, the public perception, just like whether it's a police officer, a teacher, or a judge, when you have the one bad apple, that seems to be the bad apple that gets played again and again and again. And today with the Twitters and Facebook and Snapchats, that continues to run on a continuous loop. When it gets shown again, then it pops back up to the top and it continues to show. So I think there's bad apples everywhere. I would challenge the youth of today to come to the court. So one of the things, again, in this podcast with Elon Musk, the person who was interviewing him was being cynical of the justice system. And he paused the interviewer and said, I believe in judges. I believe in the justice system. I believe that they do the right thing the majority of the time. But what you hear about is the judge in Pennsylvania who was moving the juveniles to a certain facility, and he was getting kickback money, and then he went to prison, right? But you keep hearing about that. So I was to hear it from a business person talking about the justice system, I think I was smiling at that point driving in the car coming back from Michigan. But so I would challenge the youth of today to come into the system and to actually, whether it's the municipal court or our court or an opportunity to just, you could go down, for example, I have this week on the 14th a class going to the medical examiner's office, and they give weekly tours of what they do there and how the system works. The public defender, the prosecutors, they give opportunities for you to come and shadow and be a prosecutor for a day or a public defender for a day. So really come and see how the criminal justice system works. 12 years in private practice, and again, a successful practice. I always tease my bride of almost 30 years that when I told her I was going to run for public office and take a pay cut, it was a lump in her throat. But obviously after stopping and understanding what I wanted and what I felt was missing, that idea of giving back to those people in a way, people being the citizens of Cuyahoga County, how could I best do that and play a role and maybe potentially be a role model to those individuals? So we continue to do that. I would challenge any teacher that's listening or that you know of just to pop into our Court in the Classroom website, and you could sign up for an opportunity for a judge to come out to your classroom. And we do that because we know that funds were cut and students can't travel on buses anymore to come down and get that experience. So we'll bring the courtroom to you and let you have a chance to understand how the justice system works. And we celebrate, so it's not all bad. We talk about expungements and dismissals and probation and graduations from veteran court. So it gives them an opportunity to know that it's not a system that is one that you walk into that's dark.
So I want you to know this was not a plant. Mary is on staff here at the Bar Association. She doesn't know this, but we have our monthly publication, the Bar Journal magazine, that's going to come out the November issue is a little late, but it should be out next week, we hope. My column this month that I wrote goes exactly to this point. We spent a lot of time talking about constructively what can be improved about the system. We don't spend enough time, I think, celebrating and talking about what's working well in the system. And so I challenge all of you and all those who read the article to share your insights about where you've seen it working well and what must we preserve about our existing system as we build our future system. Yes, we can do better, but there are some real hallmarks of good things that we need to make sure that carry over.
I think one of the things, again, just off target for a minute, that I see being done with judges is being able to train a new judge who's coming in, and I'm seeing that training happen more and more now than it was in the past. I didn't have the training 16 years ago, but then I found it and I've continued to go to it. But how do you present yourself to the people in your courtroom that regardless of the outcome, whether there's a victim or someone who goes to prison or someone loses or someone has to pay, how do you present that case and that experience so that when both parties leave, they say, this was fair, I don't like the outcome, but what happened was fair, right? And so as judges, that's something that we are beginning to have more discussions about in baby judge class is how do you handle yourself in the courtroom, right? There's too many times we use legal terms in the courtroom. And I went to a class over last year where now I attempt to speak on that level where I'm speaking to my fourth grader. Not because everyone in the room is a fourth grader, but that level of, do you understand you're going to waive your right to a trial? And then you pause and think about, what does waive mean? I mean, does it really? So when you have that conversation, it's really, do you understand that right to have people really judge your case and hear the facts, right? To make so I describe and understand so that when people leave, I have more people leave the courtroom that lose, that say, thanks for this opportunity. Thanks for being fair. Thank you for controlling the courtroom, right? Two lawyers that shake hands afterwards or in their closing argument thank me in front of the jury, because it was a great experience regardless of what the jury decides. So that's really where I believe the training is happening for us judges to get that open in the community so that they see that as well.
That's great. I
Is
think
that training mandatory?
So some of our baby judge class is mandatory. It's a 2-week class that the Supreme Court runs, and that's mandatory as well as some others. But as judges, we have 40 hours of judicial conduct that we have to take. So that's in addition to lawyers having their CLEs, we have an additional 40 hours of judicial conduct that plays into professionalism and ethics. And so that's additional that we take as judges as well.
the other piece that I would just give, and I'll come back to your question real quickly, is I would give you a shout out, Judge, is that in the time that I have known you, the 5 years of your 6 that you've been in the AJ role, you have been an outward proponent of your judges getting out of their chambers and getting involved here at the Bar Association, other community activities, et cetera. The critical importance of making sure that people stay connected and stay involved. I think it's essential, and I will tell you, I've already put a bug in Judge Sheehan's ear to make sure that he continues, because I think it adds also to that baby sort of training concept of new judges, the critical importance of staying connected to real people and hearing real issues. Yeah, sorry, you had a question.
So as we work on bail reform efforts and efforts to decrease the number of people in the jail, is there a mechanism in place for some of the funds that would be saved by not having such a huge jail population come back to the community to help perhaps ameliorate some of the conditions that lead to so many people having to come in front of the justice system?
Yeah, so that's a great question. One of the things I think our executive has spoken about, which I think is important too, is although that number I think we'll know maybe in May, and I say May because the programmers who were hired, DLR, they're going to be findings that are going to be made, we believe, by May of next year on what are we going to do? Is it rebuild the Justice Center? Is it build somewhere else, the jail, whatever it might be? The efficiencies of whatever is decided. So whether it's build a new jail, for example, the jail proponents would say that 1-pod floor jails are better than a 7 or 9-pod jail. So that moving people from just a 1 floor, so you have a pod that has women, men, maybe people that have mental health, people who are recovering from addictions, and then the jail pods are all 1 floor, that the moving of those are much more efficient, you don't need staffing. So that type of recommendation would give cost savings. And what are those cost savings? I mean, in the millions and millions of dollars in cost savings. And that, I think, is going to be given to us at some point, will be some recommendations about what we should or shouldn't do with the current jail and justice center. And the executive has talked about reinvesting that money, maybe some of that money reinvesting in maybe the new jail, the new justice center, so it isn't a burden to the taxpayers, and that money can be reinvested in whatever we decide to do with the jail. But the opportunity to reinvest in the community has not been discussed, but would be, really an opportunity to maybe put out there as, could you take a portion of those cost savings and use it as education back in the community? But that one section or that thought process has not been discussed, but I like it.
One final question from anyone in the audience or anything on Facebook?
What do you mean, it's 1 o'clock?
See how quickly it goes?
I have to go back to work?
You don't? I don't see any here. Let me just sort of ask you,
Sure.
as a wrap-up question, as you look out, or look back maybe, at your last 6 years, and lots of accomplishments, some challenges, certainly some opportunities that are still sort of coming to fruition. Is there a high point for you as you think about your 6 years as AJ that really is a standout, something that you are most proud of?
Well, I would say 2 things if I can.
Yeah, sure.
So
You're the judge.
yeah. There's 2 things that are going on with administrative judge. So if you could just pause, I told you about my wonderful Fortune 500 company. And so I'd like to say that over the last 6 years, the culture of the court, that idea that who do we serve and how do we best serve the community has been a push of mine for the last 6 years for the employees that work for me. And I'm very proud of the fact that we now have yearly training and diversity and inclusion training and civil treatment training, and that we have individuals who come with a smile on their face. And I was told that this dark cloud sat over the county Justice Center and that people didn't like to come to work. And so I'd like to say that dark cloud is gone. And is it gone completely? I'm not totally sure, but I think there's more sunshine than dark clouds over our court. And I told the young lady who we hired today that I sat and talked about her 2 kids and her husband, and exciting to have her with us, and that, is this your career? And if it's not your career, I'd love for you to use this as a stepping stone to your next career. But if it is your career, I want you to be able to find where you want to be in 10 years from now. I want you to know that this is a company that's going to continue to grow with you. And so I've hired, which I think is pretty amazing, in 6 years, now over half of the employees that work for us are new employees that have come in. And some of that trend with retirement will happen. So on that end, I like to think that that cloud, if it's there, it's still allowing sunshine, and that culture at the court has changed. We've trained all our frontline staff, and how do you greet someone with a smile? And how do you greet the people who pay your salary? So that's been a big push of mine. So, and on the other end, slowly this idea, before it became this bail bond issue, quietly I had moved us to the first appearance docket. Before it really became prevalent in the community or in the United States about bail bond. So if you start to go back when I came in and I started to move the first appearance docket in place, it wasn't about bail and bond, but it was about the constitutional right of the accused. And the bail bond is the constitutional right of the accused, and the centralized booking is the constitutional right of the accused. And how do you move along that pendulum? I would think that my coming in as the administrative judge, that was a big concern of mine on how do we get someone a lawyer and a bond review when they hit the doorstep of the county jail. And that was unfortunately on the 3rd or 4th day by the time they got to us. So I would like to think that maybe I was a little cutting edge, maybe out in front of the bubble with the first appearance docket, but now that the bubble is burst and now the discussion is right in front of all of us, that, hey, I have no issues with that first appearance docket disappearing into what we call a pretrial service bail bond review at the initial time they come into the felony docket. So I don't have any issues with that first appearance disappearing and it never being called the first appearance docket, but it really is the constitutional rights of the accused and the public, right? We're here for public and the alleged victims. So there's a lot of individuals that are concerned, but to charge someone with a crime and accuse them of something is important to make sure the constitutional rights attach. And so those are 2 things that I'd look back at. That you didn't give me that question ahead of time, so I had to think off the cuff there. But I think
You're pretty good on your feet.
I think I would do those.
Yeah.
I use those as my 2 points.
Those are 2 good points. Well, listen, please join me in thanking Judge Russo for joining us today. I appreciate your willingness to come and have this kind of frank dialogue with us and unscripted, and look forward to it. And again, I'm disappointed that we didn't hear back from the county executive's office, but we very much appreciate your willingness to come talk through these. We have a bonus hot talk scheduled for next week, a week from today. It will be at a different start time because one of our speakers teaches, and so we won't be able to start until 12:30 on Tuesday. But it is on the impeachment process. You might have heard in Washington, there's this little thing about impeachment happening. There are a lot of questions, and we have 2 tremendous experts who will be joining us to sort of demystify and make it real for us. So we hope you can join us either in person or back on Facebook a week from today, beginning at 12:30. And thank you again, Judge Russo.
Yeah, thank you. Thanks for coming out on a cold day.
Absolutely.
Okay, I'm not going.